You'd think this would be simple, right? A homeowner asks their HOA for some records, something they're totally entitled to by law. But what starts as a straightforward request ends up in this wild legal battle with a twist ending that I promise you won't see coming. So picture this. You're convinced your HOA is hiding documents from you, just illegally stonewalling you. You take them to court, feeling confident, but then the judge rules against you and sides with the HOA. How on earth is that even possible? Well, that is exactly what happened to a homeowner named Alexander Winter. And yeah, the court order is crystal clear. It says the HOA is the prevailing party, and the case is just dismissed. To get how a judge got to this stunning conclusion, we actually have to go back a bit, because this was not their first rodeo. See, this whole thing was actually round 2. And in the first legal fight between Mr. Winter and his HOA, the outcome was the complete opposite. Mr. Winter actually won, and it was a clear-cut victory. In that first case, everything went exactly how you'd expect. He asked for documents in June 2013, and when the HOA blew past the legal 10-day deadline, he filed a petition. By January, the judge's ruling was decisive. The HOA had broken the law. They were ordered to hand over all the records and pay him back for his filing fees. It was a total win. And when I say it was a win, I mean it was a big one. After that ruling, the HOA had to turn over 3,200 pages of documents. So this wasn't just some small victory, it was huge. So, with a win that big in his pocket, how did everything go so wrong for him in round 2? Okay, so that brings us to round 2. Feeling emboldened by his success, Mr. Winter filed another petition, pretty sure the HOA was still hiding things from him. And this time he had a brand new, very specific shopping list. So his new list included stuff like old delinquency reports, past budgets, and a bunch of vendor contracts. But, and this is the absolute key to understanding this whole thing, he also asked again for some items from the first case, specifically contracts for 2 companies, Renaissance Community Partners and CleanCuts. That little bit of overlap, well, it changes everything. So, how in the world did the judge make sense of this new, more complicated request? Well, he didn't look at it as just one long list. His approach was actually really simple and pretty brilliant. He just broke Mr. Winter's list down into 2 separate groups, and by making that simple split, he could apply 2 totally different legal rules, which is what ultimately unraveled Mr. Winter's entire case. And here they are, the 2 groups. First, you have what we can basically call the phantom documents. The HOA's manager testified under oath that these records just didn't exist. Then you have the second group, the déjà vu documents. For these, the judge pointed out that the arguments about these specific contracts had already been heard and settled in the first lawsuit. For those phantom documents, the judge's reasoning was incredibly direct. He said there was just no credible evidence that the reports or contracts Mr. Winter was asking for even existed. And the law is pretty simple on this. An HOA has to give you records it has, but it doesn't have to create records out of thin air. All right, now for those déjà vu documents, the ones that were a repeat from the first go-around, the judge didn't even bother re-examining the evidence. Instead, he brought out a very powerful legal tool that's designed to stop lawsuits from going on forever. That tool is called collateral estoppel. The easiest way to think about it is as the legal system's official no-do-overs rule. Since the whole issue of those particular contracts had already been argued and decided in the first case, the judge ruled that Mr. Winter was legally blocked, or estopped, from trying to fight the exact same battle all over again. So after all that, what can you take away from this fascinating legal saga? Because this isn't just one guy's story. It's got some really important lessons for anybody who lives in an HOA. It really all boils down to 3 key things. First, just like Mr. Winter's first win showed, you absolutely have a protected right to see HOA records. Second, that right has limits. An HOA can't give you something that doesn't exist. And third, the courts really, really value finality. Once an issue is settled, it's settled. You know, this case really shows you 2 sides of the same coin. Mr. Winter won round 1 because he knew his rights, but the HOA won round 2 because they understood the rules of the legal game, rules like collateral estoppel and who has the burden of proof. It's a perfect example of why you've got to know both. And all of this leaves us with the fundamental challenge, the real head-scratcher at the center of this case. Look, it's one thing to prove a document exists, but how in the world do you prove a negative? How do you prove a document was never created in the first place?
It's an incredibly high bar to clear, and in this battle, it was the hurdle that ultimately tipped the scales of justice.